If you've ever sold or bought a home in Hawaii, you've probably heard the word escrow. But if you're like most people I talk to, you're not entirely sure what it actually means or what's happening behind the scenes during the process. And here's the thing, understanding escrow doesn't really matter until it does. And when it matters, it really matters, especially if you're a senior selling a home after 30, 40, even 50 years, or if your family is dealing with a trust sale after a parent passes away. Today, I'm sitting down with Darrelle Glushenko, who is an escrow expert here in Hawaii with over 35 years of experience. She is here to simplify the process, specifically for seniors and families going through a real property transition. We're going to cover what escrow actually is, some things you might not have realized, and some common concerns that come up, especially when a trust is involved. This is one of those conversations I wish every one of my clients could have before we begin the home selling process. So I'm really grateful Darrelle is here. Let's get into it. Okay, Darrelle, let's start at the beginning. A lot of people talk about escrow. They say they know what it is, but lots of times they don't really know what it is. What is escrow and why does it exist?
In its simplest terms, we're the neutral third party, and we basically ensure that the buyer and seller, the terms that they've agreed upon in the contract are followed through.
Let's say we had a property of $1 million. What would the escrow and title fees be like, and who pays for it?
Title and escrow fees are split between buyer and seller. It's based on the sales price. So the sales price sort of drives those costs. At $1 million sales price, the escrow fee would be about $3,000, and that amount would be split between buyer and seller. And then for title fees, roughly about $3,700, and that would also be split between buyer and seller.
Okay, I think that's helpful. So now let's get to the meat of this, why we really want to understand escrow. We work with a lot of clients who have trusts. Some clients who have their own trusts, or clients that their parents have passed and the estate is in a trust. So let's talk about how escrow is impacted differently when it's a trust and things that we think about that we could help clients with.
Yeah, that's a really good question because I feel like a lot of clients are not informed about that. So whenever there's a trust involved, escrow, for title insurance purposes, escrow will request a copy of that trust and any and all amendments. And usually it's the full trust document. And the reason being is that the trust can say something about the particular property that we're handling in any area of the trust. And that's why we ask for the full trust documents.
Okay, based on that, one of the things I've noticed is, what if there's trustee changes? Like, I can understand you wanting the full trust because of that. What impact does trustee changes have, and how do you deal with that?
Yeah, that's a great question. If there is a life-changing event and there's a change in trustee, whether the original trustee has passed or is unable to serve as trustee, if the property is in land court, we may need to do a petition. And that's another reason why we would need to have all the trust documents as well.
Okay, and I think we skipped discussing between, in Hawaii, we have land court and regular system, right? So tell us a little bit about, how we're a little bit different from the mainland, or there are different systems.
Yeah, so Hawaii has two recording systems. Land court is more like a title registration system, and regular system, or the Bureau of Conveyances, the official state recorder's office, is like public recording system. And so if the property is in land court, petitions are needed for any life-changing events.
Okay. Is there anything we should know specifically about petitions?
For sure.
I have found that we have run into this word petition in the middle of escrow, and it has caused a lot of heart palpitations. So tell us a little bit more about petitions.
Yes, petitions take time. That's the biggest thing, clients should understand, is that if there are any concerns with title or any life-changing events, as I mentioned before, that should be brought up to your real estate agent right away. The time frame could be 6 to 8 weeks for those filings.
Yeah. And I have found that clients that I work with, we discuss whatever changes, they give us a trust early, we do preliminary title reports early, we're able to apply for petitions early and not have a problem.
Yes.
But I have been in transactions where some of the sellers that maybe, and I represent the buyer, they were unaware. We were unaware that they were unaware. And then all of a sudden we're ready to close and we got to wait another 6 to 8 weeks. So that's really good advice for people to know. It's like if there's any life-changing events and you have a trust, and especially if it's in land court,
Yeah.
that combination is something that really needs to be looked at early on.
Yeah. I can't say enough about the importance of talking with your real estate professional before you plan on listing the property and getting the right information ahead of time.
You know, it's interesting, Darrelle. You talk about needing the full amendments and all that. One of the things when I talk about clients about trusts, I always tell everybody, you know, life changes all the time. It's really good to update your trusts every 5 years. But I'm thinking that creates a lot more addendums. So what does that mean for escrow when we have all these additional addendums?
It is good advice. It's really good advice to review your trust every 5 years. It just means that they have to provide those amendments to escrow as well. So it's important that they keep everything together, and they know, you know, if they have 2 amendments or 5 or whatever it is. It's essential to provide all those right documents to escrow for insurability purposes and to make sure that we are having the right trustee sign on behalf of that entity, that trust entity.
That makes sense. That makes sense. If they can't find it or there's situations, are there like, I think you mentioned at one time, maybe affidavits or different things? And if you can explain that a little bit.
It's another good question. And again, sort of goes back to what we said earlier, the importance of reviewing trust stuff in advance is that there might be an affidavit or there could be an appointment of successor that's needed. There might be additional documents that have to be included in the trust. And so again, why it's important to have it all in advance. If an original trust is missing or something, other things might have to take place before we can facilitate closing.
That makes sense. When you hear trust and document it all, it sounds so easy. But when we work with clients who have had a trust for a while, have had the trust maybe 30, 40 years, even some people, and a lot of life elements have changed.
Yes.
They've changed beneficiaries, they've changed trustees and all that. They don't realize the paper trail and all the documentation that's required so we can make sure it's still being done properly at the very end. Yeah. So I think it's life and trust, you know, it just all happens. Yeah.
Yeah, it's exactly right. Corinda, one of the things that I really appreciate about what you do, your approach with your clients, is how you do this pre-work, meaning getting the title work done in advance and then gathering all the right documents, which I think is so important because that's how delays and stress are avoided. And you do that very well over the years that I've gotten the opportunity to work with you.
I'm always trying to see if we can get the red flags done early. Like if there's anything, let's know it early. My clients know that we do a lot of pre-work so that when we start in, it gets really smooth. I have a story of clients that we did that early, which was really good. It's a family. Grandma had passed away. Property was in the trust. That's what the family said. When we pulled the title, got the prelim, it showed that the property was no longer in the trust and that there was a reverse mortgage that no one knew about. What had happened was a granddaughter had talked grandma into getting a reverse mortgage so she could borrow some money to do something she wanted to have done, but no one else in the family knew. And the company required, the mortgage company that was doing the reverse mortgage required that it be pulled out of the trust to do the mortgage.
Yeah.
But it never got put back into the trust. So when grandma passed away and we pulled the preliminary title report, it was shocking to the family. Not only was there a reverse mortgage that they weren't expecting, the property was no longer in the trust, so we had to go to probate. So luckily we did this early enough. It still took several weeks to months to get all this taken care of.
Yeah.
But because we did it early enough, we could work through it, and it was one of those stressful events that would have been more stressful had we waited to do this, put the for sale sign up, did that, get the offer, and then start pulling that out. So yeah, it does make a difference. And that is one of those stories that really explain why it's important.
Yeah, and I was waiting for you to say that probate word because that does add more time. Just like probate and petitions, they take more time. And I think the importance of doing things in advance saves escrow people so much stress, as well as buyers and lenders, right?
Yes.
So I think it just makes a transaction run so much more smoothly, and we can adhere to, whatever closing dates that are set in that contract.
Exactly. And when you mention probate, what triggers in my mind is the fact that we really want to avoid probate.
Yes.
That is the reason people have a trust. They
yeah.
have a trust so they can avoid probate. But what happens every now and then is people will tell me, oh, I have a trust. I'll pull up the title and the property is not in the trust.
Right.
They have a trust, but they did not fund the property into the trust. They did not change the title. And so I tell people, let us know, because, all they need to do is have a petition, or how is that done to change the title?
If it's land court, then it could be a petition requirement. But if it's, oftentimes, and I've come across the same type of situations where clients say they have a trust, but they haven't deeded the property into the trust.
Yes.
So that title transfer has to occur.
Yes.
For that to happen. So again,
that deeding is called the funding of making sure that that property is in the trust name, which is important.
Correct.
Then I think along those lines, the other thing I found is sometimes people will have the property in the trust. We sell the property. They don't realize you have to have a bank account in the name of the trust, because escrow is required to write the proceed check in the name of how it's held on title. And if it's in the trust, the check is written into the trust. You guys can't just arbitrarily decide, I'm going to write it to this beneficiary. Or even if it's your own trust, you can't just write it however you want. It's in the trust name. Is that correct?
That is correct.
Okay.
And that's a good point. I think we do have, a lot of clients who say, I don't have a bank account set up for this. But the proceeds from the sale of that property get written to the vested owner. And that's important to know. So if it's, so-and-so trust, that's how the proceeds are distributed.
Mm-hmm.
Yeah.
Okay.
And so it's important that they have a bank account. And I think, most oftentimes it's so good for clients to talk to their tax attorneys or CPAs about how proceeds are distributed. And there is, some benefit to it being handled within the trust.
That's really good. I think one other point when it comes to trust is when it's in an estate and the funds are part of the trust. I think it's important for people to understand two things. One is, if the trust is a Hawaii trust and the person has passed and they were living in Hawaii, they are not affected by HARPTA. But if they hadn't been living here for a while, even if it is a Hawaii trust, they still are impacted by HARPTA. Is that correct?
They could be, yeah. They could be. Depends how that entity or that trustee is filing taxes on behalf of that trust.
That makes sense.
Again, we're not tax people, so that would be something that would be determined by their tax attorney or so forth. But they could be affected by that Hawaii withholding tax.
So that's something that people don't expect sometimes. So I think it's more like those red flags.
Yes.
All we want to do is understand the red flags early on.
Yeah.
I think another red flag is when, it's not really a big one, but the fact that they might not have gotten the EIN number for the trust.
Correct. And
they're trying to still use the Social Security number, but the proper way is to get an EIN number. And like you said, they should talk to their accountant about that, right?
Right. And a lot of times, sometimes clients will say, I still have grandma's Social Security number, but when the original trustee, has passed, there's no longer the trustee, an EIN number is the best route to take. But again, that would be a conversation that they should have with their CPA or tax attorney.
Okay. I think one other thought that comes to mind, all these thoughts with all our seniors that we've been helping over the years, and all the different things that come up. I think another one is power of attorney. Because I'll have people, parents have passed and they want to use the power of attorney. They're like, it's okay, Corinda, I have the power of attorney. I'm like, I don't think you understand how the power of attorney works. It doesn't, you don't get to have it forever. Yeah. But there's a lot of nuances to the power of attorney, like how long it's good for, the communication that you have to have with the people for the power of attorney and all that. Can you elaborate on that for us, Darrelle?
Yeah, sure. A great point to bring up, because we do get this scenario brought to us a lot. I sort of look at power of attorneys as a temporary document. And the one thing that people should understand whenever we're presented with power of attorney documents, we always need to verify with the principal that the power of attorney document is still in full force and effect. So if you give me authorization to sign on your behalf, an escrow or title company would need to call you and say, hey, is Darrelle still authorized? And that's important because this is just, it's not a forever document.
Right.
It just allows the attorney, in fact, to sign on behalf of the principal for this period of time.
Okay.
And it's usually specific to the property.
Okay. What happens, say we get a power of attorney from mom. She's getting older. We get the power of attorney, and within a year from there, she's got dementia. She's really not all there. If you call her, we have a trust, and the trust does allow power of attorney, because I know that's one of the things we got to make sure the trust does allow power of attorney.
Correct.
So we have a trust, it does allow power of attorney, but we're at this stage. What advice do you have?
So usually in those scenarios, a power of attorney would not be the document that we'd want to utilize. If mom is the trustee, it might be a good time to speak with the trust attorney and look at, maybe appointing the successor trustee.
Okay.
Someone who is able to understand what is happening or what the trust is doing and go that route rather than use a power of attorney document. That kind of wouldn't be the scenario where you'd want to use one.
Okay. Yeah, when it comes to trust, there are so many different ways to handle it.
Yeah.
And we always say, yes, definitely talk to your attorney about this, because the trust attorneys know the different ways to do it. Correct. But I think it's more important, like I said, everything we do is to red flag so that we can make the process of selling a home a lot smoother, so we're not finding this out at the end of the day.
Right.
Here's another situation we come across. What if there's one trustee, multiple heirs or beneficiaries? How do we deal with that?
Escrow deals with the trustee only. We do not deal with the beneficiaries. And as I mentioned earlier, everything that gets distributed to the trust as the owner of the property or that entity that owns a property.
So Darrelle, another situation we come across is that there's an estate and there's a trust and the parents have passed, and there's one trustee that's in charge, but there's like 5 or 6 siblings. There's several beneficiaries. How do you guys deal with that in your communication?
Good question. We deal with the trustee. Escrow does not get involved with the beneficiaries. We do not distribute funds to beneficiaries. As I mentioned before, proceeds are distributed to the owner of record or the entity, which would be the trust. And the trustee is responsible for distribution and so forth.
Okay, Darrelle, now that we've gone through all this, what is like one thing you really want families to take away from all this?
I would have to say again, the importance of meeting with a real estate professional when you're thinking of selling. So, meeting with the right real estate professional that can guide you to the resources so that you can facilitate closing. I think that's the one thing I would say.
Yeah, because at the end of the day, we want to make sure it all goes smoothly.
Yes.
Everybody closes, because our ultimate goal is to reduce the stress.
Yes.
Make the process simpler.
Yes.
Okay, I appreciate that.
Yeah.
So Darrelle, between the two of us, we started real estate about the same time. 35 years experience for you, 35 plus experience for me. So together, that puts us at about 70 years of experience. Either we're very experienced or very old. I'm not sure.
Sure.
I will say during these years, we worked a lot together. We've had a lot of clients, and I think it's been very rewarding to help so many clients. Some of them have been easy and fun.
Yes.
Some of them have been a little emotional and dramatic. I mean, we've even had one where we had clients where you had to go to the hospital to get them to sign documents. During COVID, we've had people we've had to go through, watch them sign in another room because we couldn't be in there.
Right.
We've gone through a lot helping our different clients. What are some of the things that you remember from the things that we've done, or just the feelings or the joy of any stories that you have?
I don't know if I can pinpoint one. I think I said, initially how much I really love this field. And I think because there's so much learning and it changes. It's always
constantly.
different.
Yes.
The people are different, the transactions are different. But I think when you can just help that family, give care to their aging parents or, buy their first home, those experiences, they just don't leave you because you know that you've done everything you can to inform them and prepare them well to go through this buying or selling experience.
Yes, which is really important.
So
I think it's important for me that that I've worked with you all these years because it's really we handhold the clients through it
yeah.
and it relieves a lot of stress. And the nice part is because we've done it so long, some of the people we've helped now that we're helping their kids
Yeah.
go through the process, so that's a lot of fun. And we've benefited a lot from it. We've met a lot of wonderful people that have given us great personal advice,
Yes.
even on where to travel,
Where to
what to
travel.
do, and stuff like that.
Yes.
So it's just been really great. And I just really want to thank you for doing this with us today. Thanks, Darrelle.
Absolutely. Thank you.
I want to thank Darrelle so much for breaking all of that down. Here's what I really want you to take away from this. Escrow is not something that just happens to you while you wait. It's a process with real deadlines, real requirements, and real consequences if things aren't in order. And for seniors, selling a family home, especially one held in a trust, the more prepared you are going in, the smoother it goes. If you're thinking about selling your home, reach out to us now to help you understand what preparation could be needed. Every situation is different. Every timeline is different. We are here to advise you, guide you, and help you with strategic planning and timing. I've worked with families who started planning 2 years in advance and families who needed to move in 30 days. Whatever your situation, we're here. Link is in the description. Let's talk.